Catherine, I can't understand anything you're saying, okay?
No, stay there.
I can't understand anything you're saying, okay?
So, why were you trying to climb the fence? It's very simple. And is this your vehicle? It's white. Is this one yours?
No, sir.
Then why was the door open? Because right now we have trespass on the airport grounds. That's a crime. Okay, do you understand?
435.
I understand.
On July 15th, 2022, Charlotte County Sheriff's Office deputies responded to Punta Gorda Airport on reports of a disruptive woman in the employee parking lot. What this footage presents is a textbook intersection of Florida's disorderly intoxication statute, federal airport security law, and Fourth Amendment detention doctrine.
I can't hear you. Where do you live?
I live in Fort Myers.
Oh, how'd you get here?
My friend, I'm sorry.
How did you get to this airport?
She works here.
She works here? So where are your shoes and everything?
Okay, you said the employee parking lot. Act like we don't know where the employee parking lot is.
Tell me.
My
I
boyfriend
said go
works
south
here.
from the FBO building. You walk down the sidewalk, come straight south.
My boyfriend
How long
Just walk
have you
down by
been
the FBO,
here?
that sidewalk.
maybe
Walk
like
down,
an
walk
hour.
down south,
Huh?
right by your vehicle where you park your vehicle. Keep walking down
maybe
past
like
that
an
FBO
hour.
building on the sidewalk.
I'm sorry.
Okay, so what?
down here.
Where's the car you had?
Here.
The golf cart?
Yes, sir.
Where's his car?
Yes.
You tried to jump in my vehicle before when it was parked over there.
Are you? Okay, so what's your name? And how old are you?
I'm 26 years old.
You have your driver's license or something on you?
Yes.
Can we see it, please?
Where's it at?
Where's it at? It's not in your pocket. You've been drinking. Are you drinking tonight?
Yes, sir. I should not be driving.
It's okay.
I'm sorry.
You can't. It just you're making a scene here today. You can't be out here drunk like this.
No.
No, I didn't see a climbing the fence. You did try to get in my vehicle over there by the administration.
Okay.
Sorry. I'm sorry.
So
Can I please talk to you? Mom.
who do you want to talk to?
My mom.
Well,
My.
right now we gotta get you taken care of. So
Yes, sir. I understand.
you're in the
understand.
airport,
Is
so
that-
things are taking a little more serious.
That's your vehicle over there, that white car?
Which is the one with the door open?
Yeah. Is that your car?
May I please?
Is that your car over there?
Yes, sir.
Let's go to that car.
Let me see. She said her boyfriend works here or something.
Catherine.
Whose car is this?
This is my car, sir.
Whose car is this?
This is my car, sir.
Huh?
This is my car.
Your what?
My car. My car. My car.
It's your car?
Starlet, what year was that female born?
I'm sorry.
Sit down.
Sit.
We
Where's your purse and ID and all that? Where's...
That's me.
Catherine, I can't understand anything you're saying, okay?
No, stay there.
I can't understand anything you're saying, okay? You're all fine until I ask you questions, and then you want to start crying the way I can't understand what you're
Well, you're
saying.
acting like you're crying because there's no tears coming out of your eyes.
Sorry.
So, why were you trying to climb the fence? It's very simple. And is this your vehicle? It's white. Is this one yours?
No, sir.
Then why was the door open?
Sorry. I really.
There's nothing to be sorry about. You're an adult, so you're going to have to
I'm sorry.
tell us what's going on. There's no, I'm sorry about this, that, the other. What is going on and what's going through your mind? All right?
Right now, can you please?
Listen, we're done with that. Talk.
Can you please?
Because right now we have trespass on the airport grounds. That's a crime. Okay, do you understand?
435.
I understand.
Right, so the crying, guess what, does no good. So don't placate me. What were you doing? Sit down.
Catherine, are you advising it's a different last name?
What do you want?
They were flying out.
I think she non-rev. I'm going to double check, but I think she was a non-rev.
Yeah.
Here, I got it pulled up.
What's who's registered to the car?
Yeah, she went with us.
She non-revved with the dogs, right?
Yeah, she went with us.
Yeah.
She went to,
Her and her daughter.
What does she do for the airline?
She's a flight attendant.
She's flight attendant.
So yeah, her and her daughter non-revved this morning, or a couple hours ago.
Her and her daughter?
Back with us, though, did
They didn't come back. They're not here.
So they left it over here to.
She left her badge in her car.
So we're trying to figure out how the car door was unlocked or
Carter
something.
was just unlocked. She drove the back one first. And then went to the front one.
Okay,
I
because
figured as long as she was in there, she wasn't trying to get over
Well,
the
yeah,
fence.
they non-revved her.
well, ain't nothing for her to take in her, to be
Her and
honest. It's
her
actually
daughter
pretty clean.
non-revved.
And I knew you
So-
guys were coming pretty quick, so I was like, well, I'm not going to go over there and argue with her. So.
No.
What flight did you come on?
Yeah.
But yeah, so
I
she's
just
on
was-
vacation then.
I was wondering if we had like a contact info we can call her and see if she even knows this person.
Well, we can, yeah.
It's not damaged or nothing taken out of the car. It just looks like she was
only
trying
there
to.
for like 2 seconds.
Yeah, she probably looks like she wants to find some place to sit and hide. So, honestly.
Yeah, she tried to get in mine while I was sitting there, and I was like, hold on, let me get your ride.
She got dropped off here somewhere. Or that's her car in the ditch up here. Because there is a car up in the ditch right up the street.
Really?
Yeah. So.
And I guess she was.
She's about
Does she not know anybody? There's no one supposed to be in that car, right?
No one's supposed to be in that car, correct? It's
I got you.
okay. And your relationship to her is her husband. Okay, yeah. No one's supposed to be in that car.
You don't know anybody named Catherine or anything?
You don't know anyone named Catherine?
Anything like that?
Probably like
26-year-old female, so.
no.
Okay. No problem, we'll handle it. Tell them there's nothing missing or damage in the car.
Yes, more or less. And the lawyer says that there's.
Under Terry versus Ohio, 392 U.S. 1, 1968, an investigatory stop requires only reasonable, articulable suspicion, specific, observable facts, justifying temporary detention. A barefoot woman without identification in a restricted airport parking zone at midnight reported attempting entry into occupied and unoccupied vehicles satisfies that threshold without question. Florida Statute Section 901.15. 1 codifies Terry and state law, authorizing temporary detention of any person an officer reasonably believes has committed, is committing, or is about to commit a criminal offense. The subject's employment relationship with the airport does not neutralize the trespass exposure. An off-duty employee without her badge, having departed the facility as a non-revenue passenger earlier that day, no longer holds the authorization required under Florida statute. Section 8, 10.08. Section 8, 10.08 defines trespass in a conveyance as willfully entering or remaining in any structure or conveyance without authorization. The vehicle she entered belonged to a stranger who confirmed no relationship with her. That establishes the core element. The witness account that she attempted entry into an occupied vehicle is legally significant. Under Florida Statute Section 8, 10.02, entering a conveyance with intent to commit an offense constitutes burglary a felony. However, without evidence of specific criminal intent beyond seeking shelter, the more defensible charge remains the misdemeanor trespass. The subject voluntarily admitted to consuming alcohol and marijuana. These admissions were made during a non-custodial investigatory stop. Under Berkemer v. McCarty, 468 U.S. 420, 1984, Miranda warnings are not required during field questioning that has not yet become custodial. Every word she offered was legally usable. Those admissions, combined with the officer's direct observations, glassy eyes, incoherent speech, unsteady behavior, and emotional dysregulation, form the evidentiary foundation for Florida Statute Section 856.011, disorderly intoxication in a public place. Section 856.011 requires the subject to be intoxicated and either endanger safety or cause a public disturbance. Attempting to enter occupied vehicles in a restricted airport zone satisfies the public disturbance element. This is a second-degree misdemeanor carrying up to 60 days in custody and a $500 fine.
What does your boyfriend do here? What's her name?
Well, all this boo-hooing don't do us any good. What do you want?
I'm not a good. I'm literally.
What are you on? Are you drunk? You don't smell it, so you might be having vodka or something.
No,
Right.
I have
Smoke a pot?
I drink and smoke it. I drink and smoke it, but I'm not drinking.
So you drink and smoked, right? And your eyes look like you're screwed up, okay? That's why I'm wanting to know.
I understand.
So all this is not doing us any good.
I'm sorry.
The handcuffing decision requires analysis under Graham versus Connor, 490 U.S. 386, 1989. Reasonableness is judged from the perspective of a reasonable officer on the scene, not with 20/20 hindsight. At the moment of arrest, the officer had a confirmed report of vehicle entry attempts, corroborating witness testimony, voluntary impairment admissions, direct physical observations of intoxication indicators, and a subject who had repeatedly acknowledged a lawful sit-down command and failed to comply across multiple minutes. Repeated, knowing non-compliance with a lawful command during an active detention removes the ambiguity from the probable cause analysis. Under Dunaway v. New York, 442 U.S. 200, 1979, arrest requires probable cause, and probable cause existed here across multiple independent grounds. The force level, applied soft, empty hand control and handcuffing, sits at the lower register of the use of force continuum. No strikes, no impact weapons, no elevated force. Under Graham, this is proportionate and legally defensible given the totality of circumstances. One procedural vulnerability warrants attention. Miranda warnings were not captured on camera after handcuffs were applied. Once the subject was physically restrained and informed she was going to jail, the encounter crossed the custodial threshold. Under Miranda v. Arizona, 384 U.S. 436, 1966, any statement obtained during custodial interrogation without prior Miranda advisement is presumptively inadmissible. Post-handcuff statements on camera create a suppression risk that the state attorney would need to navigate. The subject's repeated requests to contact her mother do not constitute an invocation of the Sixth Amendment right to counsel. The right to counsel under the Sixth Amendment attaches only upon the initiation of formal adversarial proceedings, not during field arrest. However, Florida Statute Section 901.25 provides that a person in custody must be afforded reasonable telephone access at the booking facility. That right is facility-based, not field-based. The officer had no legal obligation to facilitate a call at the scene.
Alright, I'm telling you to sit down. Give me your other hand. We've been telling you multiple times to sit down, and you haven't sat down.
Sit down. What's your last name?
We'll just take it for this and talk.
Trespass.
Please. Can I please talk to somebody else? Please.
Stay here.
No. Please. Please.
No, you're going to jail.
Please. Please. Can I talk to someone?
Yeah, you're going to jail. Talk to them in jail.
Mom! Mom!
Really? Mom? You're 26.
Please! 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 I want please! Please! You just said ouch! My mom is cancer and is dying of cancer!
Loud in my ear.
Have a seat.
Take a seat.
Can you please help me hold my baby? Please. I'm not trying to be rude.
Take a seat.
Please.
Are you not able to go in there? Do you need me to help you in there? Put one leg in. Alright, am I putting you in there? Are you going or am I putting you in?
I'm sorry.
All suspects are innocent until proven guilty. Thank you for watching.
Now for the grades. The deputy receives a B-. The detention and arrest were legally grounded across multiple independent statutory bases. Force calibration was appropriate, graduated, proportionate, and resolved once compliance was achieved. The deduction reflects two issues. First, the absence of on-camera Miranda advisement following handcuffing creates a documented suppression vulnerability. Second, The officer's dismissive response to the subject's disclosure of a terminally ill parent represented a missed de-escalation window that may have shortened the non-compliance cycle. The subject receives a C+. Her situation was sympathetic, but sympathy does not alter legal analysis. She entered restricted airport property without authorization, attempted entry into multiple vehicles, and admitted to dual substance use without invoking her Fifth Amendment right. Credit is given for not physically resisting once handcuffs were applied. Physical compliance at the point of arrest reduced injury risk and avoided additional charges under Florida Statute Section 843.01 obstruction or resistance. Charlotte County Sheriff's Office receives a B. Functional body camera deployment and a 2-officer response to an impaired subject in a restricted zone reflect sound operational protocol. The deduction is for the Miranda compliance gap visible on camera, a training deficiency with direct evidentiary consequences. 3 lessons from this encounter. First, voluntary admissions without Miranda are admissible during non-custodial stops, but the moment of handcuffing is a hard legal line. Departments that do not train officers to deliver Miranda advisements immediately upon arrest will repeatedly face suppression motions on recoverable evidence. Second, airport facilities occupy a heightened legal context. The combination of federal aviation security law and state trespass statute means that conduct tolerated in a public street, such as sitting on a curb without shoes, carries significantly elevated criminal exposure in a controlled access aeronautical zone. Third, impairment disclosure is not a defense, it is evidence. A subject who voluntarily tells officers she has consumed alcohol and marijuana has supplied the probable cause element that the officer might otherwise have struggled to establish without a formal field sobriety evaluation. The Fifth Amendment right to silence exists precisely for this moment. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.